Hey everybody, thank you so much for joining our webinar this evening. We are really excited to have attorney John Skiba joining us, aka Consumer Warrior. Thanks so much, John, for being here with us tonight. We're excited to talk a little bit about how to win a debt collection lawsuit.
Yeah, no, absolutely. I'm happy to be here again.
Yes, awesome. Everyone watching, please feel free to start dropping your questions in the chat. If you have any questions about being sued for a debt or how to settle a debt lawsuit, go ahead and ask away. If we're having any issues with audio or visual, also please let us know. But with that, we're going to go ahead and get started with a few questions. So before we jump into our viewers' questions, John, I wanted to ask you a couple questions, preliminary questions, I guess. But before we get into those even, I wanted to also give you some time to introduce yourself and tell us who you are and what you do for a living.
Yeah, no, I'm happy to be here. It's been a handful of times that I've had a chance to come on here with you and with George, and so it's been great. I'm an attorney in the state of Arizona. I represent people in consumer debt issues, people who are being sued by debt collectors, junk debt buyers, original creditors. Do a little bit of debt settlement, and then I also do consumer bankruptcy work. So I've been doing this almost 21 years here in Arizona. I'm in the Phoenix metro area, but I handle cases all throughout the state of Arizona. And so this is what I do. And like you mentioned, I do a YouTube channel as well. I think that's probably how we got in contact. The Consumer Warrior YouTube channel, where I put up a lot of videos where we talk about these exact things that we're going to talk about today.
Yeah, so also for context for everyone watching, John has helped thousands of families resolve debt issues. So he's definitely an expert in this space. We're excited to ask him some questions today. With that, I'll go ahead and ask you my preliminary questions, like I said. John, can you tell us, from your experience, how likely would you say it is that a collection agency will sue a consumer?
It depends on. There's a lot of different factors that go into it, and surprising, it's more high tech than you might think, and even more than I thought originally. I remember right when the COVID was starting to close everything down. There was an article in the Wall Street Journal about Encore Capital. That's the parent company to Midland Funding, and they were talking about the algorithms that these companies use, particularly the junk debt buyers, who are just gigantic. I mean, the latest statistics I saw, most of the large debt buyers file over 500,000 lawsuits a year throughout the country. And they were talking about things that they look at to determine whether they're going to file a lawsuit, whether you own real estate, whether you're employed. And they had all these things that they put into this algorithm, and then that helps them to decide which ones they're going to refer out. Now, what I have seen a lot of times, which is surprising to people, is you may think, okay, if I owe $70,000 credit card, I'm going to get sued for sure. And if I owe a $1,500 credit card, I'm not. And I've actually seen it almost be the opposite. I have had an attorney for a debt collector say, look, we know when we file $70,000 lawsuits against people, they usually file for bankruptcy. Nobody files bankruptcy over a $1,500 lawsuit. And so all of those kind of things go into play. It's usually a lot longer in the process than most people expect. The typical collection cycle, the credit card company is going to do 6 months of internal collections. They're going to charge it off. And then most of them will sell it to outside third-party debt buyers. They may file a lawsuit, but most debt buyers I see don't even file suit for anywhere from 1 to 4 years after they receive the account. Some creditors are different. American Express, in my experience, is the most aggressive. They usually file a lawsuit within 12 months of charge off. So there's a lot of different factors that go into it. But for most people, if they're going to sue, it's going to happen around 1 to 3 years after you stop making payments.
Gotcha. So it may take a few years before they decide to sue, and it sounds like they have an entire mathematical equation, an algorithm that helps them determine which cases might be worth pursuing in a legal setting and actually taking people to court for those debts, right?
Yeah, I mean, they're mining information. It's interesting because we kind of view the credit reporting agencies like Experian, TransUnion, Equifax. They're almost like these quasi-governmental agencies because they impact our lives so much. But they're just private companies, and if you look, they sell your information to collectors and to junk debt buyers. They have things called trigger reports that they send out, where if there's some change that they believe will lead to them being able to collect from you more effectively, that trigger on your report will notify the debt buyer that, hey, maybe we ought to file the lawsuit. I get people a lot that say, hey, it's, such horrible timing. I'm just applying to get into a house, and all of a sudden I'm getting hit with all these lawsuits. It's not a coincidence. These credit reporting agencies in general, are not your friends. So.
Interesting. That leads to my next question. So if you have been sued by a debt collector, how can you win a collection lawsuit if they have proof that the debt is valid? Are there any loopholes you can make or take to still win?
I mean, the first thing you have to do is file an answer. I mean, 95% of people who get sued by a debt collector, they don't take that first step. So, I mean, that's the number one way you're going to lose, is if you don't respond to it. And that's why I know Solo Suit's big on, has some products that help with filing the answer. That's the number one thing that you've got to do, is just don't ignore it. I see a lot of people who just think, oh, if I ignore this, it'll go away. It's going to get way, way worse if you do that. So filing an answer opens up the door for a lot of different avenues. And part of it, you have to decide what does it mean to win the lawsuit? There are cases that, you can take to trial, you can win, you can get the whole thing thrown out and you don't owe anything. But if someone's suing you for 10 grand and you settle it for $1,500, I think that's kind of a win. You saved $8,500. So I think that's what you really need to look at, is one, file an answer, and two, look to see what's your idea of success in this case. Junk debt buyer cases, they're going to have a lot more legal issues than an original creditor. If American Express sues you, they don't sell their debt typically. It's going to be tough to win that case, because they're going to have the documents, they're going to have the witnesses they need. At least you assume they do. But if a Midland Funding or an LBNV Funding, if they're the ones who are suing you, there's been a few more transfers of documents and information and witnesses. You may have some legal arguments you can raise in a trial type setting. And particularly depending state to state, it differs significantly as far as how the courts look at these kind of cases. Those are going to be the kinds of things you're going to want to look at. But in general, if the actual creditor who you have the card with is suing you, unless there's identity theft, I tell people you need to look at it from a settlement approach, or even a bankruptcy approach if there's a lot of debt, to try to resolve it that way.
Yeah, and just from my perspective, having worked in this field for a few years, I would echo what you say, John, about responding. Creditors are willing to work with you if you've gone through life events or circumstances that have made it hard for you to pay off your debts. The worst thing that you can do is just ignore them. So just be proactive and respond. Even just responding before it gets escalated to a lawsuit can go a long way and can actually help you settle the debt, even for less than maybe the original amount, especially if you can demonstrate that you have a real reason to not pay it right now. So my other question for you, John, is how do you fight a false debt collection? So we talked a little bit about, if the debt is real, what do you do to settle it or respond? I think the most important thing to do is just be proactive and respond. But what if the lawsuit is over a false debt or a fraudulent debt?
Even more than a legitimate debt, responding is still the key. Debt validation letters, if you get something that just doesn't seem right, or if you're getting letters from a creditor and you're thinking, I don't even know what this is, the debt validation letter, again, I know Solo Suit helps with that. It can be something really simple where you send them a letter, and then they have to provide you information so that you can make a good decision. I actually have a case right now here in Arizona in my practice where this person was sued, or they got a letter from a creditor saying they owed the debt. They didn't even know what it was. And so they didn't do anything. They got sued by that creditor, and they still didn't file an answer. They reached out to the attorney and said, hey, I think this is identity theft. And it ended up going to a default judgment. And then a month later, the creditor sends them a letter saying, you're right, this was identity theft. Sorry, our bad. The problem is there's a default judgment now that we're having to try to unwind that whole thing. And so communication is key, like you were saying, right from the get-go. If there's something you don't recognize, or even if there's something on your credit report, you can dispute it. You can request a validation of the debt where they're providing information. And then you may find out, hey, maybe it is something that I wasn't aware of, or maybe it's something where, hey, there is identity theft going on here and you need to take action on it. And I have found if you can Usually if there's a lawsuit involved, they're going to have you fill what's called an identity theft affidavit, where you provide information about it. But responding to it and making it well known early on, because one of the things that the creditors always bring up in trials, they're going to ask, did you ever dispute this? And if you're only disputing it at trial, it doesn't go a long way with the court. It's important to dispute it early, get validation, do that early on.
Yeah, so it seems like the answer is just pretty much the same across the board, whether the debt is real and owed or if it's invalid for whatever reason. The best thing you can do is be proactive and respond. Engage
Absolutely.
in these conversations with the debt lawyers, talk to the debt collectors. In my experience, and I've actually called debt collectors and negotiated with them and have some experience doing that. And typically they are willing to work with you. It might take some, research and expertise to know what to say to get them to work with you, but they will work with you. The key is just to communicate.
Yeah.
Awesome. Well, with that, I say let's jump into some of our viewers' questions, if that's all right with you, John.
Yeah, absolutely.
Awesome. So we'll just go ahead and start from the top. I might skip around here and there. But our first question is from CM Marie. It says, I lost to summary judgment to LVNV funding, and the judge requested them to submit a plan for final judgment. Plaintiff has not submitted for over 90 days. Do I have any recourse?
Some of this is going to be procedural. I mean, here's my little attorney disclaimer. I'm only licensed in Arizona. So from state to state, procedures can be a little bit different.
Yeah, and
However,
before you continue, John, I do want to say also as a disclaimer, while John is an attorney, he's not your attorney. He doesn't represent you in this case, most likely. And so the information we're sharing is simply information and resources to help point you in the right direction. Probably don't want to take it as official legal advice. Due to federal regulations, we can't give legal advice if we don't represent you. So yes, with that being said though, John, what can CM Marie do?
Yeah, I always say I'm just some guy talking on YouTube. So take that for what it's worth. If you need legal advice, talk to an attorney in your state. I can tell you this. So summary judgment, that's pretty standard procedure. If summary judgment's granted, then the court will say, okay, submit a proposed form of judgment or something for the judge to sign. The judges don't draft their own judgments. They expect the winning party to do it. If they haven't done it, you might want to look at your rules of civil procedure. Google Scholar is a great place to just put, whatever state you're in. Nevada rules of civil procedure. In Arizona, there is a time frame where they have to submit it. They usually have 20 days to submit the proposed order. I can tell you this, if they don't submit it timely, I guess you could file a motion to dismiss for failure to prosecute the case. My experience tells me, though, that even if you file that, they'll probably just reach out to the plaintiff and say, hey, what are you doing? Submit your order, and they'll sign it then. But as far as like the time to appeal the judgment, that does not start until the judge actually signs it. So right now it's kind of in limbo. You could just file a motion to dismiss and for failure to prosecute and see if the court will sign it.
Great. Next question is from Jimmy. It says, I've received some love letters from Scott & Associates recently. Scott & Associates is a big debt collection law firm. It says, while I have not been served yet, I want to be proactive. What would be some good things to do in advance?
I always think, I think it's good, if you to find out, one, if a lawsuit has been filed. In a lot of jurisdictions, you can look online on the court's website. You might be able to even, they have a case finder feature. See if a case has been filed. If one has, then I always say don't avoid service. I get beat up online all the time for saying this, but to me, it's better to deal with it, know exactly what the timeline is for you to respond, rather than run the risk of some kind of default judgment being entered. You can actually call the court. And get a copy of it. You can run by the court, get a copy of the complaint and summons. That's not service. They still have to serve you with it, just so you can get an idea of exactly what it is you're dealing with. Or if there's no lawsuit that's been filed, you can reach out and to Scott & Associates there and see if something can be negotiated. The settlement discussions pre-litigation are not admissible. It's Rule 408 with the rules of evidence in most jurisdictions. And the reason why is they want to encourage the parties to discuss potential settlement. And so they're saying, look, try to get this resolved. But if you can't, they're not going to be able to run into court and say, hey, they offered me $500 6 weeks ago. They can't do that. So there's really no harm. I do caution people. I wouldn't give out financial information. Don't give them your bank. Don't give them your employment. They're just creating a file so that when they get a judgment, they can garnish you down the road. So you got to be careful of that. But at the same point, there's no harm in reaching out and see if you can throw out some kind of low settlement offer and just get it resolved early.
Yeah, I think that's a great thing to point out, that you can contact the law firm specifically, Scott and Associates, and negotiate a settlement beforehand before you have to even go any further with the court process.
Yeah.
I also want to, just share some information from the solo suit side. We have a tool called Solo Settle. It's a digital platform where people can go on and negotiate with collectors like Scott and Associates until you reach a settlement agreement. And then once an agreement is settled, Solo Settle will help you manage getting all the proper documentation that you need to prove that the debt was settled, and also make sure that it gets filed with the court, that the case gets dismissed. And then we also can help you transfer your payment over to the collector, keeping your personal financial information private, secure, and pay off the debt through the settlement platform. So again, that's called Solo Settle. It's a really good tool to use, even if you haven't been served, even if you haven't been sued. You can use it to negotiate with collectors, to avoid having to go through the whole court process, which can be intimidating. John, I'm sure you can, speak to that, having years of experience in the courtroom. Most people want to stay out of the court. And I think most debt collectors also want to stay out of the court process. So really settling outside of court can be like the best option. So I'm going to drop a link in the chat to settle your debt through Solo Settle if that is something that you think would be helpful through the process. Next question is from Mary. It says, the judge set a pre-trial conference for next week. I cannot pay even 50% of this credit card debt. I am on Social Security. I'm afraid that they'll put a lien on my house. I have a mortgage. Should I deed it to a family member?
A couple of things there. One thing, anytime I have a client who's on Social Security, that's the one deviation from what I said earlier. I let the creditor know. I say, hey, my client's on Social Security, because what that tells the creditor is we're not garnishing this person. They can't take that money out of your bank account. They can't garnish it. It's protected. It's exempt under federal and state law. And so all of a sudden, that gives you quite a bit of leverage. Sometimes they'll just walk away from it. I've seen it, particularly if it's a low dollar amount they're coming after, they may just drop it because they know that they can't collect on it. So I would let them know. Sometimes I'll do it with like a low settlement offer. I'll offer like a 5 or 10% settlement proposal and say, by the way, income here is only Social Security. Now, as far as like liening your house, they can. In most jurisdictions, if they get a judgment, they can then record it with the county recorder, and it will act as a lien against your property. And so if you go to sell it or if you go to refinance it, they could get paid out that way. But if it's something where, like I said, the Social Security, that's a big thing that you can use to your advantage to try to get it resolved. Was there something else? For some reason, I thought there was something else that.
Yeah, they were asking, should I deed the mortgage?
Oh, yes.
Should I deed my house to a family member?
No, I wouldn't do that. The reason being, if you transfer assets out of your name, and then while you're getting sued, it can be viewed as what's called a fraudulent transfer. Fraudulent transfers are when you're essentially getting rid of assets when you know that something's coming down the pike here that's going to cause problems. They can actually, if it was a big enough judgment, they could actually undo that transaction. It's also something, if you ended up filing for bankruptcy for whatever reason, a bankruptcy trustee could undo that transaction. The risk to the home, to me, is minimal. Worst case scenario, they file a lien against it, and then you can still try to negotiate it down the road. But I would just try to settle it, making sure they're fully aware of the Social Security aspect, because I think that's something that'll help you get it done pretty quick.
Great answer. Thank you. Next question is from Pamela. It says, same situation as many others. Health took my ability to work. I'm on Social Security. How do you win against powerful attorneys, etc.? I understand they cannot take my Social Security. So I think you kind of just spoke to this question. And I shared a link in the chat, Pamela. It's a link to a blog post that we made about how Social Security income cannot be garnished. But John, do you have anything more to say about that?
Yeah, I mean, just making sure that it's known that that's what you're dealing with. The facts do matter, particularly if they have an attorney. The way I view my job sometimes is I have got to provide the creditor's attorney with enough information to be able to justify whatever they're going to recommend to the creditor, to their client. And so if it's something where, there's medical hardship, family hardship, there's been a death in the family, job loss, Social Security, I present that. You just kind of got to do the narrative of, hey, here's what's going on, just to be real with them. Again, that information's not admissible if it goes to trial, and see what they can go to their client. Because I always try to paint a picture of, look, this is how it is, and it's not going to get any better. And so take what I'm offering, or, we can fight it, or they can get a judgment and then not collect on it, whatever. But I think that the Social Security thing and your underlying facts are a pretty big deal.
Yeah, I agree to that. And the Solo Settle tool also has an option for you to submit documentation that proves that you maybe are only earning Social Security income or any other hardship information. So that's actually built into the Solo Settle app. And again, it's a really great way to get those negotiations started and not have to actually talk to any collectors directly. It's all through the digital platform. But yeah, great advice, John. Thank you for sharing. Next question is, can a refinanced car be taken if a judgment is lost?
If the creditor has sued you and got a judgment, and as far as how they collect on it, most creditors, they look at wage garnishment, bank levy, and recording it. I can tell you, at least in Arizona, I've been doing this, like I said, 21 years. I've never had a judgment creditor actually try to take a car. In most jurisdictions, it's kind of cumbersome to do that. They have to get what's called a writ of general execution, and then they have to go out and find a vehicle that's, there's no liens against it. Most states have exemptions that protect a certain amount of equity. Like in Arizona, you can have a vehicle with up to $15,000 of equity that's protected. And so it's tough for them to do. I don't see it happen a lot. I would be more concerned with bank accounts, wage garnishment, that kind of thing, than I would them going after personal property or personal belongings like that.
Awesome. Next question is from Jacoby. It says, would anyone have any advice? I was sued, and during mediation, I was able to get an agreement, but the other defendant would have to pay me back. But he never did, and he moved out of state. So it sounds like there are two people being sued in the same case. During mediation, it says again, I was able to get an agreement, but the other defendant would have to pay me back. But he never did, and he moved out of state. Any advice?
Yeah, I mean, so now you're in a situation where positions have changed, because that's an agreement. I guess the question would be, is it something that was actually part of the settlement agreement? Usually with a mediation where there's some kind of, settlement that's brokered by a mediator, they're actually going to put the terms of it in writing. If one of those terms was, hey, my co-defendant here is going to reimburse me or indemnify me for the amounts that I'm paying, it's a binding agreement. It's binding on not only you and the creditor, it's binding on your co-defendant. That would be the basis. And if they're not paying you, then they breached it. That's a breach of contract. So really, it's depending on the amount. It could be a small claims. It could be an actual other claim. Usually, if it's something they're out of state, it's going to be, truthfully, it's going to be difficult and take some legwork probably on your part, because usually you have to sue the defendant in the state that they live in. So you're going to find out where they live, what county they're in. If they're not willing to voluntarily pay you, you're going to have to file a lawsuit, get a judgment. And getting a judgment does not mean getting money, just because of what we're talking about here. Then you're in the situation of having to look for wage garnishment, bank levy, all that kind of stuff. So yeah, it's kind of a bad situation, but that's really going to be the remedy to try to get it done.
Would that be a situation where you could sue the other defendant? I'm not saying you should, but is that an option potentially?
Yeah, and that's what I really mean. You're going to have to find out where they're at, because you have to sue them in the county where they live. And so it's going to be cumbersome. You may have, if it's a large amount of money, then yeah, and probably you'd want to get an attorney to help you to do that. Find out, you'd have to find an attorney locally where they live so you could sue them in the courts where they live. So that would be the next step. And then, like I said, you could get a judgment on something like that because it's a binding agreement. If they agree to do it within, the mediation context, you can still go after them. It just might be a difficult thing to collect on.
Awesome. Let's see. Next question is from Bill. It says, I'm helping my hospitalized daughter in an appeal on a summary judgment for $4,000, which she has zero ability to pay. Successful in getting an appeal filed on time, but now I need some help on next steps.
So the appeal, anytime you appeal from a court, one thing I tell people that in most situations when you appeal, like if a case goes to trial, the Court of Appeals, the appellate court that's going to look at it, they're not looking to essentially do a new trial. They're just looking to see, did the judge abuse his or her discretion? And I've had appellate judges tell me, hey, I wouldn't have ruled this way, but it's not so far out of the realm of what's possible that we're going to reverse it. So it's important to understand that, and that's if it goes to trial. When summary judgment is granted and you appeal it, they review it, that we call it de novo review, where the appellate court is actually, they're going to look at it with a fresh set of eyes, and they're not just going to look to see, did the judge abuse his or her discretion? They're actually going to review it as if they were the trial judge. So that's the good thing. Summary judgment in most cases should not be granted. Summary judgment is only appropriate if there are no factual disputes between the parties. And so, particularly if this is like a junk debt buyer who comes in and, I always say they didn't loan you money, you didn't agree to pay them money. So there's immediately a factual dispute that should be resolved at trial. Summary judgment should only be granted if the legal dispute, if there's a law that needs to be applied and the judge can say, yep, that's it. Everybody agrees on the facts. We just need to apply the law. In most situations, that's not how these are. The problem is if you didn't respond to the motion for summary judgment, then usually it's deemed admitted. Or if you responded and you didn't raise any objections to evidence or those types of things, it could be difficult. So you may need to get some help with something like that, because my guess is you're probably at your appellate memorandum stage where you're going to have to file a written brief. You're going to have to raise all these issues. You have to cite to appropriate law. I'd probably recommend talking to an attorney on that. Those things are tough to do on your own. And Hannah, kind of to the point you made earlier about getting some help, whether it's solo suit or however you're doing it, these things can just take over your life completely. And so getting some of these resources can make it a little bit easier to get it done and hopefully get it reversed.
Yeah, I'm going to go ahead and drop a link to John's website for his law firm, actually. May be helpful, especially if you're in Arizona, to reach out to him if you feel like you need representation in your case. If you want to try to go at it on your own and, try to represent yourself, I just dropped another link to use solo suit. We have a lot of resources on our website, so go on over there, check it out. And if you have any questions, feel free to reach out to us. You can send us an email at support@solosuit.com with your questions, and we'll try to point you in the right direction. John, we've got probably another 10 minutes of answering questions, if that's okay with you.
Yep, that's great.
Perfect. Next question is from William. It says, what should I ask for in discovery with Midland Credit Management? They didn't answer my counter affidavit, which was for $9,500. They called me from 9 different phone numbers, and I was able to record them on and included screenshots in my counter.
Okay. I guess, kind of just general information that I give in all debt collection lawsuits is when it comes to written discovery or even depositions or whatever it is where you're requesting information, I always say be careful what you're asking for. I generally go by the rule that less is more, because you have to remember when they're suing you, they're the plaintiff. They bear the burden of proof. They have to establish that you had the original account, what the terms of it are, that you breached it. They have to show what the amount owed is. And then with the junk debt buyer, they're going to have to actually show an unbroken chain of title of how it got from point A to point B. If they can't do that, they lose. you don't have to disprove any of that. And that's kind of where we get caught up into it. I mean, I admit I've gotten caught up at myself, where we're like, I'm going to, show them that this is a big mess that they filed. But it's, my experience has taught me, look, when I go to trial, I just sit back and my job is to punch holes in their case. Because if they can't prove it, if they don't have the documents, they're going to lose. And in a lot of these cases, when these transactions happen and they sell debt, very little actually gets transferred. They call it media as far as their documents that are transferred. It's often a spreadsheet with a bunch of names, addresses, amounts owed, social security numbers, and that's it. And then they have a portal they can log into and sometimes get a couple of statements or something like that. Often they don't get it because usually the original creditor charges them for that extra media. And so if it's going to go to a default, they don't want to pay extra for it. And I know this is a long answer to your question, but it gets to my point is if you send over a request for production of documents, they have to respond to that. They may actually have to go back to the original creditor, pay for extra documents, and get a bunch more evidence than they normally would have brought into the case. And so in a weird way, you may have actually made your defense more difficult because now they have more information, more documents than they would have had otherwise. Now, it sounds like here there might be a counterclaim. If you're pursuing a counterclaim like an FDCPA claim or something like that based on phone calls and that, then yeah, you need to press it because you have a claim you have to prove as a counterclaimant. You've got the burden of proof for you is on that. If you request information, if you request documents and they don't provide it, you can file a motion to compel. Usually there's in the rules of civil procedure, they do require you to have a phone call with them first, try to resolve it. But if not, you can file a motion to compel and the judge will require them to turn over whether you're asking for recordings, whether you're asking for the original documents, the forward flow agreement, purchase and sale agreement, any of those types of things, the court will typically require them to turn over their entire file of what they have.
Very nice. I also dropped a resource on what happens during discovery. That's the process where both parties get to submit documentation that helps strengthen their side of the case. So I submitted a little blog post from our website, from SoloSuit's website, about what happens during discovery. And check that out. It might help as well.
Yeah.
Let's see. Next question is from Peyton. It says, I've defaulted on a few small private student loans, but my legal representation does not want to fight Scott and Associates. What can I do to take the fight to them? Motion to compel arbitration, etc.? ?
Yeah, I mean, whether it's a student loan or whether it's, private student loans, we should say that. Private student loan, because private student loans, truthfully, all they are is credit cards with federal bankruptcy protections, which is bizarre to me that they changed the laws back in 2005 and these basically private student loans typically don't go away through bankruptcy either, as well as the federal. It does. Your defenses are very much the same. Private student loans are often bought and sold. A lot of people have heard of National Collegiate Student Loan Trust. They buy a lot of student loan debt. And I always love those cases. If you're so lucky to get them to buy it, they have all kinds of problems. You can go to the Consumer Financial Protection Bureau's website and just see a whole bunch of consent orders about companies like that. Really it comes down to if it's the original creditor, then your options are settlement or, you mentioned trying to have it pushed into private arbitration. A lot of it depends on the amount that they're coming after you for. All of that will structure the case really and set it so that you can maybe get a better settlement on it. They do have some leverage in that they know you're not going to file bankruptcy on it, because bankruptcy doesn't really help you. So those ones I do see, they often, unless they have some real defects in their documents, that if it's going to settle, it's probably going to settle for something a little bit higher than like a junk debt buyer credit card would. But that's what you really need to look at is get the terms and conditions, go through there, see if there's an arbitration clause, or maybe you can have a private arbitrator take a look at it. If it's a junk debt buyer that's bought it, see if they have an unbroken chain of title with actual documents. When you're looking at those chains of title, a lot of times we read it and we just assume. You can't assume anything. You've got to look at it. Does it have your name, your account number being transferred, or is it just a general portfolio? That's National Collegiate Student Loan Trust problem, is all their documents just show evidence of gigantic pools of accounts being transferred, but nothing account specific. So, the private student loans, that's tough. But it's very similar to original creditor lawsuits as far as, what your defenses are.
Yeah, and to add to that, I also again dropped another link to a blog article from solosuit.com called How to Settle with Scott and Associates. You may find that information useful as well. Next question is from Linda. It says, I was sued for the final bill let me see. Oh, okay. There's more to the story here. So, question from Linda. It says, my mother passed away in April 2019. I was sued for the final bill from her residence. I never got a bill after she passed. Hasn't this exceeded the statute of limitations? I'm in California.
I don't know what the statute of limitations in California is off the top of my head. So the statute of limitations, that is from the time when the account goes into default until, like on a credit card, 6 years from the time it goes into default, they have to file a lawsuit. Otherwise, they're barred from doing it. So you need to really see when the last payment was made. If I understood the question right, if this was your mother's debt, they may not be able to do anything, with her passing, unless you were a co-signer or co-obligor on it, something like that. But I would just want to really nail down when the last payment was due, when the account went into default, and then apply the California statute of limitations based on that. Because once they have the ability to sue you, that's when the clock starts ticking. And then if it's outside, whether it's 3 years, 4 years, whatever it is, then they may be outside it, and they can still request voluntary payment. That's one thing a lot of people don't realize too, is even if the statute has expired, they can ask you to voluntarily pay it and be annoying, but they just can't sue you.
Again, I dropped another resource in the chat on the statute of limitations in California. I believe for most types of debt, it's between 4 to 6 years, but it varies depending on the type of debt. But check out that resource, and that might give you more information about California specific statutes. But yeah, thank you for that answer, John. Next question is from Jesse. It says, should you always challenge a debt collector on a debt you owe? What can you catch them on to get the lawsuit dropped?
Well, I think you can file an answer, like we talked about. That's the most important thing. And I always say you got to be truthful in what you're submitting to the court. But I always kind of joke, you need to be painfully truthful. If they file a complaint and they say you owe $5,943, unless you know for sure how they came up with that number, it's okay to say that you don't, the legalese is we say that we lack sufficient information. Therefore, we can't either admit or deny, so therefore we deny. There's things like that where you can say, look, I don't know exactly how they came up with that amount, or if it's a junk debt buyer, you for sure aren't going to know if they actually transferred it. So you can deny those things and then make them prove up their case. So even if it's something like, yeah, I know I had the card, you can still respond to it. You can respond to it truthfully, but then really hold them to their proof as far as establishing how they came up with the balance. Did they apply the payments correctly? Has the statute of limitations expired? Those types of defenses, I think, are fine to bring up. And, like I said, most cases end in settlement. I tell my clients that. I mean, I do this all day long, every day, and I've done a lot of trials. I've done over 400 trials against debt buyers. I have a trial tomorrow morning against a junk debt buyer. But most of my cases settle, because that's generally, there's always risk in trial, always. And particularly if you're representing yourself, you've got to remember you're going against an attorney who they do this all day long. And this may be the first time you've ever even had any contact with the court process. Using, something like the settlement tool, something like that, it doesn't hurt to see exactly what you can get, and it gets it out of your life. In Arizona, from the time a lawsuit is filed till you get to trial is usually a minimum of a year. I've had clients say, look, I 100% have strong defenses, but I want this out of my life. So let's offer a settlement now and see if we can just get it done and move on.
Yeah, I think the ideal situation in most debt collection lawsuits is to settle the debt, because it allows both parties to avoid the lengthy court process, which can get really expensive for both people involved. And it can also just promote finding an amicable agreement, something that works for both parties. Whereas going through the court process, typically one person's going to end up feeling like they lost. So yeah, just again, being open, being proactive, having open communication, reaching out, taking those steps can have a huge payoff. I'd say we have time for about 3 more questions. That's all right with you, John?
Yeah, that's fine.
And maybe we can do a little bit more rapid fire on these next few. We've got one from Kyra. It says, I sent a debt collector a lawsuit response to the court using solo suit, and now they've sent me a request for production of documents. What is the next step in this process?
You need to look at the documents themselves. They will usually give you a time period to respond. It's usually 30, 40 days, depending on which state you're in. And you've got to provide it unless you have an objection. And, things that I object to, if they're asking, hey, what's your social security number? I object to that. If they want your pay stubs, I object to that. That's not relevant to whether you owe this debt or not. So you either need to file a written response providing the documents, or what your objection is within the time frame. That's part of that written discovery process. Yeah, you do need to respond to it.
Awesome. Larry says, I'm being sued by Chase Bank. I offered to pay 40% of the debt, and their debt collector said no. Now I have a court date in December. I've read that most banks settle for 40 to 60% of the debt, but no go. Also, I'm a court-appointed conservator for my mom who has dementia. So I work, but it's a small salary. Any advice?
Yeah, I mean, I can tell you original creditors. So Chase, particularly when the larger claims, the larger amounts, they do keep their debt and sue on it. Like I said, they're going to have the witnesses. They're going to have the documents. Unless there's some identity theft issue, you're going to lose a trial. Or it's truthfully going to be summary judgment is what's going to happen. And so it's important to know, too, the courts are not there to, it's not a defense to say, I don't owe it, or to say I can't afford to pay it. That's not a defense. The judge is really like an umpire. The judge is just there to say, does this person owe it or are they not? Are they liable or are they not? And then they lead the collection up to the creditor. So with something like that, with the original creditor, and Hannah, you guys probably have more data on this than I do. I usually see they're going to be higher. If Chase, American Express, that settlement's going to be closer to probably 60 to 80% of the total amount, rather than like a junk debt buyer, like a Midland or somebody who might settle for 20 cents on the dollar on a case. The original creditor is going to be typically a higher settlement.
Yeah, I think that's been in our experience. We've seen the similar thing where creditors, since they're the ones that owe the debt and they are more at a loss if they settle for less, they're sometimes harder to get a lower settlement in comparison to dealing with debt buyers like LVNV Funding, Portfolio Recovery Associates, Midland Credit Management. They may accept a lower amount for settlement. They're still going to try to get you to pay the whole debt, but chances are they purchased the debt for a percentage of the original amount. So even if they do settle for less, they're still going to make a profit, hypothetically. So yeah, I think that's a really good point to make. Let's see. I think let's go until 45 after the hour, if that's cool. I know I'm trying to push it a little bit because we had a lot of questions today. We had a lot of people join. Thank you, everyone, for being here and watching. Adrian says, I'm being sued by Portfolio Recovery and Capital One. I'm not sure what I should do. I know Portfolio is a third party, and I'm hoping to gain some insight on how to beat this case.
Yeah, with Portfolio, they're a debt buyer. And so it's the same thing. You file an answer, and then in most jurisdictions, they're going to provide you a disclosure, some kind of, their documents, their evidence. You're going to be looking to see, do they have a bunch of monthly statements? I always look for that. Can they establish the amount owed? And then usually their biggest problem is establishing that chain of title. Did the original creditor transfer it to Portfolio? Is there something showing your specific account? There's always a bill of sale, but it's always a generic one that just says, a pool of accounts was sold on this date. It usually says they're attached as Exhibit A, and there's usually no Exhibit A, or there's some kind of spreadsheet that they've kind of just, thrown together. Those are the kind of defenses you're going to have. You may also have private arbitration as far as pushing the case out of the court system into private arbitration. You're going to have to look at the terms and conditions of the original creditor. You mentioned, multiple lawsuits. I do tell people, who come into my office here in Arizona, if it's something where you have a lot of lawsuits and they're just coming one after another, you might want to start looking more at a bankruptcy option at that point. If it's something if you win against portfolio recovery and then 2 more lawsuits get filed next month, it may be something where it's time to start looking at kind of a global solution to just dealing with all of it at once.
Awesome. Well, I think we're going to go ahead and wrap up now, but thank you again, everyone, for joining. We had a great turnout tonight. And John, thank you so much for being our special guest. I think we learned a lot about how to win a debt collection lawsuit, how to settle outside of court. And yeah, you've had great answers tonight. So thank you so much. For anyone who is watching that maybe we weren't able to get to your question, reach out to us at support@solosuit.com and we'll try to point you in the right direction. You can also watch our webinar next week, which will be at the same time, Wednesday at 6 p.m. Central. So yeah, please come watch, ask your questions. I also dropped 2 more links in the chat one more time. One will take you to solosuit.com where you can use our resources to resolve your debt lawsuit. The other is to work with John if you're being sued in Arizona. He can help potentially represent you in your case and help you settle the debt. Thanks again, John, for joining. Any last words before we close?
File an answer to the lawsuit. That's what we always say. Make sure you file an answer. But no, I appreciate you having me on tonight.
All right. Awesome. Thanks, everyone, again, for watching. Good luck with your cases. We are rooting for you. We hope you're able to resolve your debt. Thanks.